1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်806 The Bank of CHETTINAD Limited Applicant versus the Income Tax Assessment Collection and Inspection Board Rangoon Respondent ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Miscellaneous Application before ဦးကျော်စံဦး Judge the Bank of CHETTINAD Limited Applicant versus the Income Tax Assessment Collection and Inspection Board Rangoon Respondent Specific Relief Act Section 45 Jurisdiction of the Court limited to cases of clear breach of duty to do or forbear from doing Burma Income Tax Act Section 30 Proviso for exercise of discretion by the Income Tax Assessment Collection and Inspection Board, correctness not to be challenged, party not to be derided, has to exercise the discretion. Applications under Section 45 of the Specific Relief Act to make an order requiring the Respondent Board to allow the applicant bank to prefer the appeals against the assessment of income tax on payment of tax admitted on furnishing sufficient securities for the due performance of the orders that may be passed on appeal under the fourth proviso to subsection 1 of section 30 of the Burma Income Tax Act as amended by the Union of Burma Revolutionary Council Law numbered 27 of 1963 held to make an order under Section 45 of the Specific Relief Act. The jurisdiction of the court is limited to cases where there is a clear breach of duty to do or forbear from doing, as the case may be, that is to say, to exercise its discretion or refrain from exercising its discretion. The fourth proviso to subsection 1 of section 30 of the Burma Income Tax Act casts that duty on the Income Tax Assessment Collection and Inspection Board, the applicant bank's grievances were considered by the board, and thus it had exercised its discretion. Once that discretion has been exercised bona fide, its correctness cannot be challenged, nor can a party be derided to exercise the discretion in a particular manner. In the matter of Rudra Narayan Rule ILR 28 Calcutta 479 distinguished S.M. Mukherjee versus Russell ILR 1941 Calcutta 387 refer to Wu and Hope for the applicant, Mr. S.K. Ghosh, government advocate for the respondents. Wu Jiaosan-Wu, Judge. These three applications under Section 45 of the Specific Relief Act to make an order requiring the Respondent Board to allow the applicant bank to prefer the appeals against the assessment of income tax for the years 1961 to 1962, 1962 to 1963, and 1963 to 1964 on payment of tax admitted on furnishing sufficient securities for the due performance of the orders that may be passed on appeal under the fourth proviso to subsection 1 of Section 30 of the Burma Income Tax Act, as amended by the Union of Burma Revolutionary Council Law numbered 27 of 1963, which, stripped off the irrelevant portion, runs as follows, provided further that, notwithstanding anything herein before contained, the government or any person authorized in this behalf by the government may permit an assessee to prefer an appeal on payment of the tax admitted and on furnishing sufficient security for the due performance of the order that may be passed on appeal. The three applications are similar in nature except for the year of assessment and the amount assessed. The point involved for decision is also the same in all the applications, so this order will cover all the three cases. The proviso quoted above is concessive and give discretionary power to the respondent board. This is not disputed. See Massa, Sandley and Sons versus Income Tax Assessment Collection and Inspection Board, Rangoon, being Civil Miscellaneous numbered 174 of 1963. To make an order under Section 45 of the Specific Relief Act, one of the 5 conditions provided is that such doing or forbearing is, under the Burma Income Tax Act, clearly incumbent on the respondent board in its public character. The jurisdiction of the court is limited to cases where there is a clear breach of duty to do or forbear from doing, as the case may be, that is to say, to exercise its discretion or refrain from exercising its discretion. There is no doubt that the fourth proviso to subsection 1 of Section 30 of the Burma Income Tax Act casts that duty on the respondent board. What the court has to see is whether the board has performed its duty or not, or in other words, whether the board has exercised its discretion or not. If a statute confers a discretionary power, the refusal or neglect to exercise the discretion may be enforced by an order of the court under Section 45 of the Specific Relief Act, but when once that discretion has been exercised bona fide, its correctness cannot be challenged, nor can a party be directed to exercise the discretion in a particular manner. In the matter of Rudra Narayan Rule 1, the petitioner called upon the Board of Examiners to show cause why he should not be allowed to appear at the ensuing examination upon his fulfilling the necessary conditions under the law. About 10 years ago, he was tried for impersonation at the examination, but for lack of proof of his identity, he was discharged. About 8 years later, he offered himself as a candidate at the examination. The board investigated the case and, exercising its discretion, came to the conclusion that he was not a fit person to be accepted as a candidate. The board considered that it was entitled to rely upon the decision of the previous board and, without referring to his present status, refused him to be examined. Considering himself aggrieved by this order, he applied under Section 45 of the Specific Relief Act, praying for relief mentioned above. Stanley Judge, sitting on the original side of the Calcutta High Court, observed that if the board had gone into the question of the present fitness of the candidate and had, in the exercise of its discretion, decided that he was not a fit and proper person to be admitted to the examination, he certainly would not have entertained the petition, for it was for the board and not for the court to determine the fitness of a candidate. As the petitioner's present fitness was never considered, the relief prayed for was granted against the board. The learned judge observed that a man's moral character 8 years ago was such as fully to justify a refusal to accept him as a candidate, but he may be of a reformed and estimable character 8 years later. In the cases now under consideration, it cannot be said that the applicant bank grievance were never considered by the respondent board. It considered the case and exercised its discretion. In S.N. Mukherjee vs. Russell 2, where the applicant as under Section 45 of the Specific Relief Act that the respondent should grant an import license. Pancrate Judge, sitting on the original side of the Calcutta High Court, held that the controller, in his discretion, having refused a license, the court would not interfere in the matter. The judgment says, "My reason for refusing the application is that I consider that under the notification, the applicant cannot ask for a license as of right, and it is within the discretion of the State Controller Department to grant the license or to refuse it, and with that discretion, I cannot interfere." In Civil Miscellaneous numbered 174 of 1963, original civil jurisdiction referred to above, I had the occasion to interpret the fourth proviso to subsection 1 of Section 30 of the Income Tax Act, and it will be quite appropriate to quote the relevant portion of the judgment in that case, which was confirmed in Appeal, being Civil Miscellaneous Appeal numbered 13 of 1964. In that case, also an application under Section 45 of the Specific Relief Act was made to make an order requiring the respondent board to permit the applicant firm to prefer an appeal against the assessment on payment of the tax admitted and on furnishing sufficient security for the due performance of the order that may be passed on appeal, as in the present cases. I have said in that judgment, the word may becomes imperative only when the power is coupled with the duty, otherwise its meaning is permissive. It is clear, therefore, that the intent of the legislator, which is the test in enacting Section 31 of the Act is mainly not to allow an appeal unless the tax has been paid. This is the primary object. In view of this conditional prohibition, which is imperative in the third proviso, no duty is cast upon the board to allow the applicant firm to prefer an appeal on payment of the tax admitted by it and on furnishing sufficient security for the balance under the fourth proviso, which is purely discretionary. The board could have refused permission straightaway to prefer an appeal even if the applicant firm offered to pay its admitted tax and to furnish sufficient security. It must be remembered that I'm not sitting on appeal against the order of the board to enable me to criticize and go into the correctness or otherwise of the discretion exercise, which, as the learned advocate for the applicant bank has submitted, may be arbitrary and unjudicial, considering the fact that the applicant bank has duly paid the delay assessment of income tax for a period of about 10 years amounting to over $1 million just within 1 month of the urgent notice of demand made and undertaken to pay its admitted amounts for all these 3 cases, and is prepared to furnish sufficient securities for the remainders. It seemed that the applicant bank could not have done better. The learned government advocate who appeared for the respondent board could not challenge these facts in his argument, nor did he find any counter affidavit on behalf of the respondent board refuting the facts, though I very much regret to say that postponements had been granted from time to time as requested for nearly 2 years before the learned registrar to find reply affidavits. In the above circumstances, I have no alternative but to dismiss the applications. They are accordingly dismissed with costs, advocate fees, 2 gold mohurs for each case,